Just because you're injured as a result of carelessness, does that mean that I'm automatically going to take your case? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. The answer is no, it doesn't. There are a number of factors that go into determining whether or not I'm going to accept the case. And the mere fact that you have the first component, the first element of what's known as liability, now means that I have to evaluate the second and third elements as well. Because in order to determine first whether you have a valid basis for a case, I have to know whether there was wrongdoing. I then have to know whether the wrongdoing caused injury. There has to be what's known as a causal connection. There has to be a bridge between the wrongdoing and the injury. And then I have to see what is the extent of your injury. Then I have to see what type of permanent injury you have. What type of disabling injury do you have? Just because you have the first element where you can show that somebody was careless, that caused you some type of injury, does not in and of itself mean, number one, that you have a valid basis for a case, and number two, that I'm going to take on your case. You should remember that not every case is right for every attorney. And one of the things that we do when evaluating a possible case is we need to look at many different factors. And the first one is there liability? Was there wrongdoing? Number two, did the wrongdoing cause injury? And number three, is the injury significant and or permanent? And now we also look at many other factors. What is your age? Where did this happen? What is the likelihood that we will be successful? And we have to go through an entire evaluation and a thorough investigation to make the assessment of whether or not this is something that I'm willing to look into. Now, you should know that when you call my office to find out if you have a valid basis for a case, the very first call that you and I have will be simply a screening call. And that call is only going to last for a very few minutes. And I only want to know a couple of key things. I want to know, what do you think was done wrong? And what injury did you suffer as a result of that? And contained within those two questions, which is a compound question, are the three elements necessary for me to initially evaluate whether or not you may have a basis for a case. So why do I share this great information with you? I share with you just to give you an insight and an understanding into what goes on when evaluating a possible case here in the state of New York, whether it's an accident case, whether it's a medical malpractice case, or even a wrongful death case. In all likelihood, you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.